If you've ever leased a vehicle in California or have considered leasing one, this video is for you. As of the current law right now, dealers are required to get wet ink signatures on leases, and they do not do that. I've done a full analysis on this. Dude, I like immersed myself the other day, and I freaking came to the realization that they must get a wet ink signature. Now check this out. So there's a nuance under Civil Code 1633 subdivision C. And they have been trying to get rid of this exception, which puts an exception under for Civil Code section 2985.7 through 93. And that's the Leasing Act. There's a little exception in there. It's under subdivision C. It says it doesn't apply to that. All right. So that means that all these leases that people are getting electronically signed at dealers right now, if they don't have a physical copy, it can be void. Yeah, so credit to this guy right here. This is the attorney that actually figured it out. I mean, I thought this, James S. Seifers, Madison Law Practice. This was published in 2018, but yeah, electronic transactions have vastly simplified the way of doing documents. Several of my automobile dealership clients have inquired as to whether vehicle transactions can be documented electronically. Currently, the answer is no. The rubber meets the road. Look at this, 1633.3, an exception. Except as otherwise provided in subdivision B, this title applies to electronic records. This title does not apply to transactions subject to any of the following laws. Down here, section 2985.7. Boom. Look at this, the Vehicle Leasing Act, 2985.7. Right here. I had to amend the law right there in 2023, but that didn't apply to the old Leasing Act, which was like from 2000. See that, 1998, when they brought this Leasing Act in. So they're relying on old law. It's still current, where you have to do physical signatures. So here's what's happening. Yeah, so these dealers, what they're doing is people are going into the dealership and they're signing the contract, but there's no cancellation clause in the freaking lease. It's a freaking huge fraud. It's massive fraud. And the reason they do it, so what they do is they take it's a little electronic signature pad. It's about this big, and they say, just sign right here. And so the consumer signs a document on his thing with his finger, a little scribbler. And then by the time he gets the printed lease, it says there's no cooling off period. And the legislature has this law in place, so that doesn't happen, because you cannot cancel no matter what you do or say. There's never a possibility, unless you can prove fraud, right? Or you prove the lease was void ab initio. It never had any effect on its face. Why? Because there's no physical signature. The law says there must be a physical signature, dude. I mean, so all these leases are void. These dealers could be sued freaking by a mass tort, class action.